people, what's up? So today we are going to do your amendments people for June 2023 your attempt for company law subject. If you look at the supplement sheet people, the first thing which is provided by the institute, they have given it as applicable for June 2023 examination, and whatever is the supplements given by the institute, it covers amendments from August 2021. So certain amendments people we would have already done in the class, certain amendments we'll be doing it newly, because if something is not covered, I'll be doing. If it is already covered, I'll not be doing. So one thing I would suggest you people, whether whatever videos you have watched, if you have watched it from Arivu only, whether if it is written as old or new, whatever you have watched, whichever video you have watched, one thing I would suggest you, first watch December 2022 amendments and also watch June 2023 amendments. Always people, for whichever exam you are going, always try to watch that last two amendments and go. Yes, that is your current amendments and also the previous amendments, because the question can come from that as well as this. So always have that habit. Yes people, so watch that as well as this. So with that people, let us start your company law amendments. The list looks huge, but certain things we have already covered in the class. So very big points and all, you need not worry. With regards to CSR people, I've already uploaded a complete video of the CSR chapter itself on YouTube. It's a completely different thing. What I would say is, see, obviously the entire chapter will not be amended. But what I would suggest you, just open that CSR chapter, watch it at 1.5x or 2x, whatever the speed you want. Wherever there is an amendment, I have marked clearly that there is an amendment there. Watch those things specifically and go. Yes, with regards to CSR, do that. That would be great. Okay. Now let us start your... I said start, it just went off. So there is amendment in chapter 1 people. So whatever these committees are, how did we arrive at Companies Act? We have done this people in the class only. You need not worry much about all of this. It's okay. The Bubbles Act also I told you with regards to UK, it started. That also we have done in your batch. So you need not worry about that as well. What else, sir? How to read and understand a section. Throughout the chapter we would have seen people. I mean, we have when we were doing the chapter only, I would have told you how to read this particular topic. You will not learn it here. You will learn it throughout. Like in all the chapters, you will be learning. For example, you will always be, referring to a section. Section always tells you what to do. And if you read rules, rules tells you how to do. So you should always read section and rules together. And how to interpret a section. First, it will be called as section, subsection, clause, subclause. Correct? So all this is given there. You need not worry much about that. Sir, interpretation of some standard words and phrases used in the law. Statute is law. So certain things they have used it. What is that, sir? First one, people, wherever you use the word proviso. What do you mean by the word proviso? Wherever you have seen the word proviso, proviso means people, this condition will apply to a person, but with some modifications. There is a special condition involved. The best example I can give you is example of private company. In the case of private company, what did we see people? A private company will always have a maximum of 200 members, correct? Sir, provided. This is called as proviso. What do you mean by proviso clause in an act, people? Whenever you're reading an act, in the section, if they have given proviso, proviso means people, see, generally this is the rule. But with regards to this, there is some exception, modifications. Yes, sir. So clause which makes some special conditions, special stipulation, now that is called as people proviso. I've given you everything with example. This is not given in your amendment sheet. I've added the examples so that you can understand better. Yes, sir. That is called proviso. So next one is called as notwithstanding anything contained. Now, what do you mean by notwithstanding anything contained means people? If in a section, if the section starts with the word notwithstanding anything contained, means people, let us take an example of section 182, which talks about political contributions. In section 182, this starts with notwithstanding anything, meaning what people, in this act, you don't mind which section talks about anything. No other section will prevail in front of this section. We generally call this as overriding effect. Meaning what, people? If a section has the word notwithstanding, then no other section will prevail over this section. So the example, people, section 182 of Companies Act, which talks about political contribution, notwithstanding anything contained in any other provision of this act, a company other than government company and a company which has been in existence for less than 3 years may contribute any amount directly or indirectly to any political party. So just given you a power, you can donate. Yes, sir. So no matter in which other section there is a contradicting point. You would have seen in your jurisprudence, whenever there is a conflict between two sections, which section will prevail? So imagine there is a conflict. Now which section will prevail? You need not even think. It is always this section which will prevail because the lawmaker himself has given an overriding power to this section. Clear? Okay. Next one, people. In a section, if they have used the word called subject to. Subject to means, people, very simple. Ulta of notwithstanding. Meaning, people, if any section has the word subject to, meaning they are telling you, first read that. If that is more superior, that will prevail. This is subordinate to that section. Yes, sir. Sir, where example, people? In section 13, alteration of memorandum of association. Any change in the name of a company shall be subject to approval of shall be subject to the provisions of provision of subsection 2 and subsection 3 of section 4. Meaning what, people? They are telling you, in section 13, you can change the name of the company. Absolutely. In setting up of business entities, you would have seen also, you can change the name of the company. However, when you're changing the name, they are telling you, you have to keep the other section in mind. Which section? Section 4, subsection 3 and subsection 2. You have to keep that in mind. Sir, what is given in that sections? People, undesirable names. It should not be similar to existing name of a company, LLP, trademark. All of that is given in this section. So subject to means, people, here I'm telling you, you can change. So that doesn't mean you can change to anything. So this is subordinate to compare to that section. You have to make sure you read it with that section. Understood? Okay. Sir, next one, sir. Nothing contained in this section. So some sections will have the word called nothing contained in this section. Sir, whenever a lawmaker has put this word, what does he mean? This means a lawmaker has given a general rule in an entire section. But at the end, he will say, this section will not apply to a particular class of company. So whenever he wants to exclude a particular class of company, he will use the word called as nothing contained in this section shall apply to. Sir, the best example, people, section 173 and section 174, which talks about meeting of the board and the quorum of the board. In this, it is clearly given, no, people, nothing contained in section 173 and 174 shall apply to OPC, meaning, people, in one person company where there is only one director. Why should he have board meeting? Why should he have quorum? So for him, all that sections is not applicable at all. That is what is given here. So I hope you are getting. Sir, can we expect a question here? People, it's an amendment. Sir, so can we expect a easy? No, people, that's nothing complicated. I've given you with example also. So what is your agenda? They may ask you a 3 or 4 mark question asking to interpret what are the meaning of these 3 clauses in your statute. What does that mean? They can ask you, what do you mean by nothing contained in this section? What do you mean by subject to? So you can read and go, correct? Next one, sir. Without prejudice to the provisions contained in this act or any other act. Whenever a word says, people, without prejudice, meaning, people, it clearly says this should also prevail, that should also prevail. Meaning, people, I do not want to damage the other section. I do not want to override the other section. Without prejudice. Prejudice means, people, without affecting, without damaging. Yes, sir. Look at section 129. Section 129 says, people, subsection 1 says the financial statement shall always give a true and fair view and the company should always follow accounting standards. If you remember accounts and audit chapter, we had done this. What, sir? Sir, so should all the companies follow accounting standards? Yes, people. However, if you are deviating, you have to give the reasons for deviating. Correct? That is what is given in section 129 subsection 5. Without prejudice to subsection 1, where the financial statements of company do not comply with accounting standards. If they are not complying with accounting standards, the company shall disclose in its financial statement the deviation, the reason, what is the effect of such deviation. So without prejudice to means, so because they have given this section, no company will follow. That is not the intention. I'm not telling don't follow. If at all you are not following, then this is the remedy. But because I have given subsection 5, that doesn't mean none of you follow subsection 1. That is not the meaning. Understood? Then, okay. For the purpose of this section, provision or definition. Simple people, whenever I want to define anything, I will say only for the purpose of this section. For example, subsidiary company. In that, there will be something called as layers. For the purpose of this section, the word layer means subsidiary company. It's only for that section. Clear up? Sir, what do you mean by shall and may? By now you guys know, people, wherever the word shall is used, that means mandatory. Wherever the word may is used, that means optional. It is just directory. If you guys want, you can do. Okay, there is one more word which we... there are two more types of definition, that is called as mean and include. So people, types of definition, people, there will be some things called as restrictive definition, meaning they will say, whenever they are using the word means, that means, people, it's a restrictive definition. Whenever they are using the word includes, that means, people, it's an extensive definition. Don't break your head. I'll explain you what does that mean. For example, people, now imagine in Companies Act, there is a word called as articles means. What do you mean by articles? According to Companies Act. According to Companies Act, articles means articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous order of this act. Meaning what, people? Articles means only this document. Which document? Articles of association. No other document can be called as articles if they are using the word means. If they are telling this means this. So this means this only. It cannot be another thing. You cannot add another interpretation to it. Sir, we are not understanding, sir. I'll give you an example. People in the Companies Act only, they have given the word alter. For example, if you guys have done setting up of business entities, chapter 3b, we have something called as alteration of charter documents. What do you mean by alter? See, they are saying alter includes addition, omission, substitution. Meaning what, people? Alteration includes addition, omission, substitution. People, they have not included the word, say for example, people, replacing, sir, deleting, or, changing the entire articles only. Meaning, sir, I will take one article, I will throw it and I absolutely bring a new articles of association. Meaning what, people? The word alter includes addition, omission, substitution, or any other thing. That is the meaning of the word includes. So you should not read it as only addition, or if you do not do it, or if you are replacing something, only then it becomes alteration. Anything also can become alteration. If you change the spelling also, it can be alteration. Rectification can be alteration. So that's the meaning of the word include. If it is include means, people, the meaning will be extensive, meaning you can spread the language. You can take another interpretation. You can add words to it. Wherever they use the word means, people, it's a dead end. So article means articles of association. That's all. No other document can be called as articles. Clear? That's the meaning. So that's the difference between means and includes. Okay, now. Okay, this was already there, people, and just because it is there, again I'm telling you. Yeah. Okay. Sir, under Companies Act 2013, what are the amendments they have brought in till today? Whatever is important, just few things, know and go, people, more than sufficient. End of the day, people, Companies Act 2013, the major amendments, whatever was brought, the main purpose of the amendment was, people, keeping this words, this line in mind. What is that, sir? Ease of doing business. What is that? Until 2013, people, whatever was a compliance, imagine even if you want to register a company, if you want to file balance sheet or P&L account with ROC, If you wanted to do all those people, the procedure what was not simple. So in 2013, the main purpose of the Companies Act 2013 itself was ease of doing business, meaning however the compliances are done, whatever these procedures are, all these has to be reduced. The burden should always be reduced. So on that grounds, people they did 2013 Act. But after 2013 Act made people, still there were some obviously complaints were there, some practical difficulties were there, which professionals started facing when once they were working on that particular assignment. So that is the reason people, even after passing the Companies Act 2013, every now and then there was amendments made to that particular Companies Act 2013. Not only then, people, even till today, the law is still being amended because to remove the practical difficulties in the law, so that it will be easy to implement the law, and also wherever it is not required, some procedures they have tried to reduce it. Yes, sir. One such major amendment, people, was in Companies Act 2015. So first Companies Act 2013 came. Our shareholders, the stakeholders, the professionals like CA, cost accountant, company secretaries, all of them raised many difficulties faced in this particular Companies Act. So keeping that in mind, people, what did your MCA do, people? They formed a committee called as Companies Law Committee. Sir, what was the purpose, people? The purpose itself was that what? In implementing of Companies Act 2013, whatever are the difficulties, the purpose of this committee was, people, to report those difficulties and try to come up with a solution. Yes, sir. Sir, the committee people, they tried to, chart down what and all are the discrepancies, what and all are the difficulties faced. So they tried to bring a list. What was that, sir? This happened in 2015-16. This was a first list. Definitions to remove ambiguities. Wherever there is confusion, they wanted to bring clarity. Allowing greater flexibility in incorporation of a company. Earlier, people, you had to take central government approval and all in addition to ROC. Now they have reduced all of that. Sir, easing raising of capital if a company wants to raise money. So whatever the procedures followed, for example, prospectus and all, they have reduced the burdensome. When we are doing in class, that procedure itself you guys will feel as burden. Imagine before that what was the burden. Now whatever you have, people, is all amended. So in 2015 they introduced all of this. They formed Company Law Committee because of this. Company Law Committee, people, always remember, whenever they want to bring in any amendment, whenever they feel that there is something which is very major change required, they always appoint Companies Law Committee. They will always suggest you some changes. The changes will be considered and the law will be amended accordingly. Yes, sir. Sir, rationalizing penal provision, meaning, people, giving justification for the penalties used. Reconciling the competing objects, improving corporate governance, incentivizing individuals to take up positions of responsibility in boards and reducing compliance cost. The report have to be recommended some changes to remove ambiguities in CSR. So when CSR provisions were made, people, the CSR provisions were not completely clear. So over a period of time, even for your attempt, there are so many amendments. Yeah, small amendments. Yes. So you guys watch the CSR chapter once. Okay. So that is what happened in 2015. Sir, Committee on Review of Offences under Companies Act 2013 and the Companies Ordinance 2018. Sir, in 2018, what happened? The committee recommended that the existing rigor of the law should continue for serious offences, whereas the lapses that are essentially technical or procedural in nature may be shifted to in-house adjudication process. Meaning what, people, in 2018, the committee felt the company law is very rigorous, it's very strict. The strictness has to continue for the serious offences. For example, fraud, section 447 will apply. So if it's serious offense, let serious penalties only continue. But however, if at all a form is not filed within 30 days, there is penalty. So these things, let us not drag it. You need not file a suit on them. They need not come to court and all. Let us try to reduce this burden as much as possible. So in the year 2018, what did they do, people? They tried to shift certain sections to in-house adjudication process. Now, what is in-house adjudication process, people? If you remember, whenever there is a problem, if at all there is any complaint filed, The complaint will always be filed in NCLT if it is company law related matter. People, wherever they have tried to change the things, in-house adjudication process means people, NCLT will not come into picture. ROC only will decide those sections. If at all that section is coming under in-house adjudication proceedings. If not, people, it will go to NCLT. So with this, people, their purpose was, their vision was to reduce the burden of the tribunals also, at the same time to save certain time also. Yes, sir, this is what happened in 2018. So remember that one thing. Sir, in 2019, people, again certain changes were made. For again making the changes, company law committee was again constituted with certain different people. Now, what did they suggest? People, in this people, what did they do? See, first thing, they changed certain things. What is it, people? See, in 2019, first thing was, people, the important thing was this. What? They amended around 16 sections of the act as to modify the punishment as provided in the said sections from fine to monetary penalties. From fine to monetary penalties. Sir, what is the difference between these people? Always remember, wherever the word fine is used, wherever the word yes, sir. So wherever the word fine is used, wherever the word monetary penalty is used. Earlier, people, throughout Companies Act, only fine was used. Now what they have done, people, in certain cases, that is in the case of 16 sections, in the case of 16 sections, people, what they have done, they have tried to change the word fine to monetary penalty. Sir, what is the difference between the same thing, people? Wherever the word fine is used, the fine should always be levied by people, the courts. That is, people, NCLT alone can take the decision if the word fine is used. Wherever the word monetary penalty is used, people, ROC only can issue an order saying that this is what is a penalty you guys have to pay. So wherever the word fine was used, people, they have tried to replace it by the word monetary penalty in around 16 sections. The example, people, the best example is, try to see section of CSR. So they have changed the word fine to monetary penalty in the word CSR section. Yes, sir, that is what is one change. Yes. Next one, sir. They amended section 135. Earlier, people, this unspent CSR account and all. Watch that, you will get to know what is CSR account and all. If at all I have started a CSR project, if at all I was not able to spend the entire amount on CSR. Now, whatever is the amount still left, which I have not spent on the project, it is called as unspent CSR. Now, what to do with that money? There was no clarity. They gave clarity, people, in the year 2019. As I said, again, company law committee was formed. Sir, in the 2020, people, they took one major, step. What is that, sir? People, they took a step, people, towards something called as decriminalization of offenses. What is decriminalization of offenses, people? Wherever there are some procedural defects, meaning what, people? Whenever I pass special resolution, I have to, file form MGT 14 within 30 days. Sir, what if I do not file within 30 days? Earlier, people, whenever these are called as procedural amendments, I have to issue share certificates within certain time. Earlier, people, if I do not do all this within time, what used to happen? Directly put the directors or officers in default in jail. For minor things, people put in jail. People, if for everything, if you are putting in jail, who will start companies tomorrow? Da? Who would like to become director because of so much of responsibilities? So now what did they do, people? Criminalize means people put them in jail. Decriminalize means, people, instead of putting them in jail, I'm not telling don't punish them. Instead of putting them in jail, see whether for that do they deserve to go to jail. If not, do one thing, settle it with the monetary penalty. Just impose some penalty, be done with it. Do not put in jail for small things. So if it's a procedural mistake, procedural, non-filing and all, do not have to go to jail for all of this. So they said instead, settle all those matters with penalty. That is what was decided. Yes, this is what is the amendment which came in 2020. It's clear? I hope you guys are understanding. So, sir, authorities, agencies under MCA. What is MCA? We have seen, people, MCA chapter itself is there. Sir, under MCA, there is a person called as ROC. ROC takes care of compliances of LLP as well as companies in India. Regional director, people, comes above ROC. What is the purpose of regional directors? People, they oversee and monitor the performance of people. Regional directors oversee the performance and they monitor their things of your ROC. So official liquidator people, whenever there is a winding up provisions and all, the person appointed to take care is called as official liquidator. Serious fraud investigation office people, SFIO. Whenever there is very big frauds people that is conducted, for example, these things people, there were a lot of scandals that happened in India people, which made way for forming such committees. One such committee is called as people SFIO, Serious Fraud Investigation Office. This was started in the year 2003 people. So this will not come into every aspect. So imagine if a company fails, SFIO won't come. SFIO won't come people until and unless whatever has happened in the company is of a very serious fraud that is involved. If it's of that nature, they will involve. If not, they will not come into picture. Yes, sir. Okay. Sir, NAFRA people, we have seen the entire section only in accounts. Accounts audit, the chapter. NCLT people, they are the tribunals appointed under Companies Act. Sir, interpretation of definitions, we saw means and include, how to read it. See, there are more examples to you to understand what does what mean. For example, see, the word body corporate includes a company incorporated outside India but does not include cooperative society or any other body corporate. So this is what is the definition they have given. So body corporate includes, have they given the word LLP here? Now my question to you, can LLP be called as a body corporate? Yes, people, it can be, because the word used is includes. Imagine if they have given body corporate means incorporated outside India but does not include cooperative society or any other body corporate. Imagine if they just given means people, it will be only company. No other thing can be called as body corporate. Now LLP can also be called as body corporate. That's the difference. Understood? Okay. Sir, wherever the word explanation is given in statute, if they have given the word explanation, that means people, the lawmaker himself, all these people you should have actually studied in jurisprudence. This is a wrong place to even give all these things, but it's there. I'm just giving it to you. Sir, explanation means people, whenever a lawmaker has given you any definition, in that there will be a word. He will only tell you what do you mean by that word. For example, people, if I look at the definition of associate company means people in a company which has another company which has significant influence. Correct? Now, what do you mean by that significant influence, people? What do you mean by that significant influence? That is given as an explanation under associate company definition only. That is at least 20%, but not more than 50%. This is given in definition only. That is called as explanation. Clear? Okay. Yes, sir. Now, company law committee people, what they have done in September 2022, people, they have passed one extension order, people. What is that? In September 5th, 2022, whatever company law committee was formed in 2019, they have planned to extend the tenure for another 1 year, that is up to 16th September 2023. Whatever was formed in 2019, company law committee, if they want to extend the services of company law committee to 16th September 2023. Sir, what is the purpose? Same thing, people. Whatever the technical difficulties or whatever the interpretational problems they have with regards to interpretation of people, Companies Act 2013 that we already knew, one more act is now added to this, people, for why we extended it. What is that act, people? That is your LLP Act. Now, what does company law committee do? Company law committee will try to understand whatever the practical difficulty in implementing, people, both Companies Act and LLP Act. That is the main purpose. Understood this? Okay. Next one, people, there is one amendment in small company definition, people. According to your book, the last thing you guys would have seen would be paid up capital of 2 crore, turnover of 20 crore. A company satisfying this is called a small company. Now, people, they have changed it. What is the newly amended limits, people? A company which is having a paid up capital not exceeding 4 crore, turnover of not exceeding 40 crore. A company which satisfies both the condition is called as, people, a small company. Paid up capital not exceeding 4 crore, turnover not exceeding 40 crore. Understood this one? So this is the recent amendment. Remember this from your exam point of view, more than sufficient. Yes, people. So this is what was there in your chapter 1. Done now, simple things. Okay. Sir, next one, sir. SH4 land border. Okay. Now, people, whatever I'm giving you, people, this amendment has effect in 4 places. All the 4 places I'll give you here only. What is that, people? I'll give you a brief understanding. What used to happen if you guys were in EBCL? I've already explained you this thing also. What is that? During COVID time, people, what used to happen? We have our neighboring country, one country, I'll tell you which country. We are heavily dependent on them. But during COVID, people, all our stocks in the stock market, they started reducing. Their value started falling down, the price. So there was one country, people, that country was trying to slowly take away the country, our companies one by one. They started investing. For example, people, if Reliance shares is around 3,000 rupees today, in COVID, people, Reliance had touched around 9,800, 9,900. If you see today, you can buy only one share of Reliance. In COVID, you could have purchased 3 to 4 shares of Reliance. So imagine if you have 100 crores, you can buy worth of 400 crores that day. That will become 400 crores today. Sir, so what? People, one country does not have very good reputation, people, with regards to this foreign investment. So they will invest today, but tomorrow, people, they will take advantage of it. So we could not do it. Sir, so what, sir? They can clearly tell off, no, sir, like the way we have in FEMA. If you see FEMA, they have clearly told no person can invest if you are coming from Pakistan. We can tell off like that only, no, sir. People, with Pakistan, we have, a very big history we can clearly tell. But with the country I'm talking about, people, we cannot directly take their name because we have a heavy dependency on them. If at all they are not there, people, the cost of living in India will increase. If your phones, people, because of them, the cost of your phones are very low. If it is made in India, it will be a little high. If you go for shopping and all. So, the country which I am talking about, people, is called as China. Yes, sir. Sir, now, people, what did our government wanted to do? The government, people, did not want them to come and take control over any companies in India. They wanted to stop it. But they could not also say, just like the way we told to Pakistan, they cannot say it with Chinese government. So what did they do, people? They played one intelligent game here. What is that? They said, any person, individual or a company, if you are coming from a country which shares, land border, imagine this is India. I mean, of course, I am not drawing teacher. Imagine if this is India. So if you are coming from a country which shares land border with India, you are coming from a country which shares land border with India. So Pakistan, Bangladesh, Nepal, Bhutan, we already have sorted all these issues. Then which is the country which is only left out, people? That country was, people, your China. So we could not tell about China directly. So what did we do, people? We brought in an amendment. This is basically, it has a major impact in FEMA. But here now, what did we introduce? We introduced one provision. What? Tomorrow, if at all you guys are coming from a country which shares land border, don't write off China in your example and all. You have to write the same words. If you're coming from a country which shares land border with India, then, people, what is the effect? First thing, people, see. During incorporation of a company, if you guys are incorporating a company, in that, people, you would have seen something called as INC 9. What is that, people? Whoever are the subscribers and the directors, of the company, they have to give a declaration. What is that, people? The declaration says, sir, are you coming under? So if you are coming now, what, sir? So do you mean to say, if at all they are coming from China, they cannot invest in India? That is not what is the rule, people. If you are coming from China, or if you are coming from any country which shares land border with India, you can invest in India only after central government's approval. Without central government's approval, you cannot step into India. Understood? Now in incorporation, people, of a company, in INC 9, in subscribers and directors, they have to give a declaration. In that, people, they have to give a declaration. What? Whether do they come under a route where they need prior approval of central government or not. There is a tick mark given now. You need to say yes or no. If you're sharing a land border with Indian country, people, then you have to come under central government route. So you will say, yes, I come from such country where I'm coming under a prior approval of central government route. Now people, when you're incorporating your company, you also have to give approval given by central government with along with your incorporation documents. This is with incorporation. Same thing, people. Imagine today a person in India. Imagine a person in India called Mr. A. He is a shareholder in India. So one is in incorporation. Next one is people in transfer. Imagine, sir, there is a person in India. Now he wants to transfer his securities outside India. He wants to transfer it to outside India. To whom, sir? Again to a person who is staying in, say for example, a country which shares land borders with India. Again, people, in SH4, same thing. Are you coming under route where you need prior approval of central government? You will have to say yes or no. No means, people, you are coming within the same country. So you need not have to take central government approval. Or you are coming from US. You need not require central government approval. So people, if you need, then you have to say yes, you have to take central government approval, only then you can transfer your shares. Sir, where is this, people? This has come in SH4, share transfer form. The second place. The third place, people, if a director wants to obtain DIN, if you remember your DR3 points and all, if a director wants to obtain a DIN, same thing, people, if you are coming from a country which shares land borders in India, people, then you cannot do it without prior approval of central government. You need to take prior approval of central government. Yes or no, same thing, yes or no has to be given a tick mark. This is in DIN. Say next one, sir, whenever a director is being appointed, he will give us something called as consent to become a director in the form called DIR2. DIR2 was a consent to become a director. In this also same thing. He has to give a declaration. I do not come from a country which shares land borders with India, so I need not have to take prior approval of central government. You have to give a tick mark. The third one, whenever you are filing the form, appointment of director with the ROC, even in DIR12, you have to give a same declaration. This is the third place where the same thing has an effect. So the fourth place, people. The fourth place is with regards to private placement. Remember, people, there was something called as PAS4. What is PAS4? PAS4, people, stood for PPOL, private placement cum offer letter. In this, people, again the same thing. You will have to give a statement saying that are you coming from a country where you need to take a prior approval, and you have to take a prior approval, only then allowed. PAS4. Sir, these are the four places majorly. If there is any other thing also, I'll tell you. But these are the major places. It was clear. So make a note somewhere. These are the places that land border has an effect here. It was clear, all of you? Yes. Okay, cool. Yes, sir. This is one thing what I told you. SH4 thing. Yes, sir. We already discussed. PS4. The same thing. Land border thing. Then that's all. That is your chapter 2. Chapter 3, sir, we have already done it in the class only, people. What is that? If you guys remember, people, there was a section called as section 94. What is that, sir? Sir, inspection of register of members. So if any person wants to come and inspect the register of members, people, sir, then we used to give him the entire register of members. He can take whatever details he want. Now, people, we felt in the register of members, there will be some sensitive information, like, people, your home address. It can be your PAN. With your PAN, people, you know, for many documents, PAN will be the password. Like, for example, banking documents and all. So they said, under section 94, whenever a person wants to go and inspect the register of members, he can go and inspect whatever the register of members or index or whatever it is. You can go and inspect, allowed. But people, in that register of members, certain details, people, will not be available for inspection. You can just mark a note here. They may ask some small comment based question or something. Sir, now what is that information, people? The address of the person will not be given. If you are a company who is a shareholder, then your office address will not be given. The email ID of a person will not be given. Any unique identification number of such person will not be given. Sir, PAN number of a person will not be given. These things will not be available for inspection of while doing register of members. Is clear? A simple thing. Remember, nothing else in this particular chapter. People, the next amendment, people, a simple one in chapter 4, debt capital and deposits. What is that, sir? Earlier also this was there, people. We were filing something called as DPT3. Every year by 30th June, we used to file it. If you guys remember, that is still there, people. Nothing has changed. Then what they have added, people? Whatever the DPT3 we are filing, for that, now there is a declaration that has to come by the auditor, people. Meaning what? Whatever the deposits you are filing, so the entire deposits chapter, sir, so whatever you're declaring all the right figures only. Someone has to certify that. So someone has to declare that. Now, who is declaring, people? It will be declared by the auditor. Now, that is the amendment. Here, something called as DPT3 and DPT4 are substituted. This is absolutely of no relevance to you. Don't even bother. Wherever they have given you such things that this form is substituted, that means whatever was an old form, in that place they would have introduced some new changes to the form and they would have introduced. That is nowhere relevant for us. Don't even worry. The form will still be same only, DPT3 only. They will just they would have added some two things here. They would have changed the alignment. They would have changed the version. All that are considered as changes. So now they have added this declaration. No? Now that is the reason they have substituted the new form. That's all. So that is the only change that they have added. Clear? That's all. What is your fourth chapter? Fifth chapter, people, we have done in the class only. What are those, people? We have seen whenever a company is borrowing money from any company. So what do? We first thing what we do is called as, people, we will give something called as collateral. Whenever we give collateral, people, the first thing we do is charge creation. Correct? We have to intimate this to ROC. Whenever a company borrows money, this is the standard procedure. However, if a company, whichever is borrowing money, imagine, imagine, people, the company which is borrowing money is bank. Sir, what are you saying? Bank only borrows money. Yes, people, bank also borrows money. Ayyo, from whom, sir? If bank is borrowing money, people, the lender will always be RBI. So, sir, always remember, people, in EBSCL, if you guys have seen, I would have told you there also. What is that? This is only called as, people, repo rate and reverse repo rate. Repo rate is basically at what interest the banks are borrowing money from RBI. That is only called as repo rate. The interest charged by RBI on this particular borrowing is called as repo rate. Now, people, the banks has to get this money. Will RBI give this money free of cost? RBI will also take collateral from banks. Without collateral, RBI will also not give you loans. Now, people, whatever collateral you have given, the moment you have given collateral, what is that? People, you would have created charge. Now, should I register this charge with RBI? I mean, should I have to register this charge with ROC? Is it required? Amendment, people, this is part and parcel of banking system, people. This happens every day. And this will not be very long-term loans, people. This will be overnight loans, 14 days loans, 1 week loans, 1 day loans. For this, all this is not required. So this, they said, people, the charge creation, whatever the procedures are, that shall not apply to any money borrowed from banking company from RBI and charge created or collateral given in this favor of RBI. You need not have to register all those documents. That is the amendment. Clear? Done. Okay. And next thing, sir, whatever are CHG1, CHG9, whenever we are filing all these forms, we are filing all these forms with ROC, right? Yes, sir. All these forms are filed with ROC. Sir, who will sign these documents? Obviously, it will be signed by directors of the company. It will be signed by directors of the company when you're filing it with ROC. Okay. But, sir, if you guys have watched, if you guys have already, not if you guys do, you should have. If not, it is very late. People, if you guys have seen this subject called setting up of business entities, in the closure part, people, there is a chapter called as insolvency and bankruptcy code. In insolvency and bankruptcy code, what will happen, people? A company goes into bankruptcy. The first process will be CARP, corporate insolvency resolution process. In that process, what happens, people? A person will be appointed. That person is called as resolution professional. Once he is appointed, he takes over the management of the company, correct? When he's taking over the management of the company, how can directors sign such forms, people? So what happens if any charge is created by a company which is undergoing insolvency process? You guys can be thinking, if already is undergoing insolvency process, how can they create charge? They can create charge, people. That is only called as CARP. If at all there are ways to rescue this company even in that phase, why not? So if someone is ready to give us the loans, we will be able to borrow it. So that time, with whatever assets you have, you can give collateral. Now, sir, can directors sign the form? No, people, the resolution professional will sign these forms instead of directors. Whoever is appointed under this IBC chapter. Yes, this has more relevance in that chapter. That is your IBC, not here. Yes. Sir, distribution of dividend, people, this entire thing I'm just putting as tick mark. Why? I have made you guys write handwritten notes. What is that, people? Whenever if you want, whenever the amount and shares are transferred to IPF account, from that, how do you have to claim it back? You saw that we had seen it, people, the same thing they have given people. If you see, this has been part of 2021. We have already done that, so you need not worry. It's already discussed in the class. Rule 6, 6A, everything is done. So directly, people, see, we skipped so many parts. Done now. IPF. Okay. Done. That's all. CSR, people, I'm just putting it as done. The reason, people, what I advise you guys is watch that entire video. I've already uploaded on YouTube saying as CSR with all amendments applicable for June 2023. Watch that. Hardly it is, I think 3 parts are there. If you put all 3 parts together, it is 1.5 or 2 hours video. So watch it in 1.5x or something. Something which you guys have not made note of, make a note. Done. CSR is also done. Next one, sir. Accounts, audit and auditors. This actually we need not go in detail, people, because they will not ask you. See, if they have to ask you, those people, that background should be there in your syllabus. The background itself is not there in syllabus. But on the face of it, I'll tell you, people, what is the amendment that has happened? The amendment has happened in Indian Accounting Standards Amendment Rules, sir. Now, what is the amendment regarding, people? Now, the central government in consultation with NAFRA has notified companies in Indian Accounting Standard Amendments Rules 2021 to further amend the company's Indian Accounting Standard Rules 2015 pertaining to various Indian accounting standards, including those related to. Meaning what, people? Under Indian accounting standards, you had to give lot of disclosures and all. You need to follow all those things that is there. Now, people, under that, there was one thing, people. What? Earlier, people, whenever we issued any foreign transaction happened, people. For example, imagine we borrowed money from outside India. We generally call it as external commercial borrowing. Imagine we issue some debentures outside India. We used to call it as something called as foreign currency convertible bonds, foreign currency exchangeable bonds. All those is not there for you. Sir, for all those people, what will be the rate of interest? The rate of interest, people, we generally used to refer to something called as LIBOR, London Interbank Operating Rate, plus whatever is the bank's margin, that margin used to be the rate of interest. Imagine if LIBOR is 4% today, our margin will be 2%. Our margin will always be fixed. If LIBOR increases, people, your rate of interest will also increase. But whatever is the profit margin of the bank, that will always remain same. That will be 2%. Now what happened, sir? Now all this is not there in syllabus. Now what happened, people? In the last year, people, around 2021, this London Interbank Operating Rate, in the class I can explain this concept for 1 hour also. But how did they arrive at this 4%, this London Interbank Operating Rate? The top banks in certain jurisdictions, people, they used to control this LIBOR, whatever is a percentage, to their advantage. So over a period of time, people, for over now 10 years now, people, they have done a fraud of around trillions of dollars. People, I'm talking about trillions of dollars fraud they have done. Because they had indirectly influence on the percentage, whatever we call it as LIBOR. Now that entire scandal came out in light, people. So now they took some corrective measures. Now as a part of corrective measures, people, RBI also said till today we are all following LIBOR. Now going forward, you guys have to follow some other percentage. Almost all the countries did the same thing. Now you are not following LIBOR anymore. So now you are following some other percentage, right, as a base Till today we were following Libor. Now we are following something else, right? Now because of that, is there any impact on the company's instruments? Whatever these instruments were, is there any impact? And is it going to affect your company? And what is the new percentage you are following? You have to give a disclosure. That is what is given in the amendment. See, additional disclosure with respect to interest rate benchmark reform to enable users. Interest rate benchmark. Till today, people, we were following Libor. Now we are following some other benchmark. The nature and extent of risk from financial instrument subject to the interest rate benchmark reform and how the entity manages these risks. Because this changed, now 4% can become 2%. Now how are you managing this risk? And the entity's progress in completing the transition to alternate benchmark rates. From Libor you're changing, right? What is the progress? Have you done or is it in the on the way now? So that you have to disclose. That's the amendment. Done. Okay. Next one, people. Okay. Now, what is this, sir? The companies, again, same thing, people. What is this, sir? People, in your book, if you remember, people, again, in the same accounts audit chapter only, sir, there was something called as people, Ind AS applicability. Ind AS applicability. I would have told you from NBFCs, I would have given you a tabular column. Sir, now for some companies, people, from which day to which day, they have clearly given when is this particular provision applicable. Now there they have given you amendment, people. What? This Ind AS, whatever is the standards, the company's accounting standards, people, the MCA wide notification dated 20 has notified the company's accounting standard rules 2021 for small and medium sized companies, with which the turnover and borrowing limits has been revised, as well as disclosure requirements has been made less onerous for SMCs. What is this, sir? The revised definition. Instead, wait, I'll try to show you the revised thing only. Yes, people. So I'm just showing it to you from your module. So you could see something called as this NBFC. For them, this was applicable. This was applicable. Yes. So people, see, this is the amendment, people. What is that? Yes, sir. The company's accounting standards rule 2021 for small and medium-sized companies. Now, what does it say? See here. The company's Indian accounting standards rules 2015 shall not be applicable on banking companies, insurance companies. The banking companies and insurance companies shall apply the Indian accounting standards as notified by RBI and IRDA respectively. For banking company, RBI will tell you have to follow that. For insurance company, IRDA will tell you have to follow that. An insurer or insurance company shall, however, provide IAS compliant financial statement data for the purpose of preparation of CFS by its parent or investor or venturer as required by the parent investor or okay. The company's accounting standard rules 2021 for SMCs. The MCA wide notification dated 21 has notified companies accounting standard rules 2021 for small and medium sized companies, with which the turnover and borrowing limit has been revised, as well as disclosure requirement has been made less onerous for SMCs. Meaning what, people? There are the small and medium sized companies, people. For them, they have notified something called as the company's accounting standard rules 2021. So who are this, small and medium companies, people, that they have defined here? Is clear? Yes, now what is that, people? See, the revised definition of small and medium sized companies are the company whose equity or debt they should not be listed on, or they should not be in the process of listing also, whether in India or outside India. So you should not be listed in India or outside India. You should not be in the process of listing also, whether equity or debt instrument. It should not be a bank, financial institution or insurance company whose turnover, this is the amendment, people, it does not exceed 250 crore rupees. So for them, they have to follow this, which does not have borrowings in excess of 50 crore rupees, which is not a holding or subsidiary company of a company, which is not a small and medium sized company. Meaning, people, Imagine if there is a SMC, you are a subsidiary of a SMC only, then people, it's absolutely allowed, you are coming under this condition. Sir, if there is some other company, sir, which is not a SMC, sir, if you are a subsidiary of such company, then people, these rules will not apply to you. That is what they are telling you. See here, which is not a holding or subsidiary company of a company, which is not a small and medium sized company, which is not a holding or subsidiary company of a company, which is not a small and medium sized. If it is, then we don't have a problem. Understood? Yes, this is the amendment. It's clear. So, sir, these companies, they will follow something called as Companies Accounting Standard Rules 2021. Clear? That's all. Don't break much head there. Okay, same thing. Sir, an existing company which was previously not a small and medium sized company. So, sir, existing company, until last year it is not a SMC, and subsequently it becomes a SMC, shall not be qualified for exemption or relaxation in respect of accounting standards are available to SMC until the company remains SMC for 2 consecutive periods. So people, just the moment I touch SMC today, it is not sufficient, meaning my turnover and borrowings and all. It has to be there for at least 2 consecutive years. Only then I can come here. That's the amendment. Clear? CSR, we have done this in the class also, people. I have done this even in the CSR chapter. You can read it there only, more than sufficient. Yes, sir. Sir, again, people, this last time also we have done, they have again given the same thing. They have changed some accounting standards, people. The accounting standards itself is not there in our syllabus. Even something changes in the accounting standards, it's not our scope of understanding or learning, so we can ignore. So next one, people, again this AOC4 with regards to CSR2. I've already explained this in your CSR, people. You can watch it there. Sir, in AFRA provisions, people, with regards to penalty, there is an amendment. You can absolutely ignore it. It's fine. Yes, okay. There is something called as Ministry of Corporate Affairs clarification given on what is this, people. MCA people, in September 2022, they gave a clarification. What is that? Whenever you are preparing your financial statements or P&L account, you might get numbers like this. For example, people, 1097 rupees. What did MCA say, people? You can round it off to the next number. Meaning, people, you can round it off to the next 100. Yes, sir. So basically, this was called as rounding off provisions. Sir, this amendment clearly said the financial statements can be rounded off. Okay. So auditors started rounding it off. Okay. Now what happened, people? Whatever are the financial statements, we will fill the entire thing in the form we file with ROC called as AOC4. In this, people, the MCA language, they did not bring amendment saying that whatever is the financial statements given by the auditor, can we take the same number, that is rounded off number, or should we take a number which is not rounded off? If I round off, will it be considered as a non-compliance? If I do not round off, will it be considered as a non-compliance? So they said, people, whether you do a round off also, it's not a non-compliance. Whether you don't do a round off also, it's not considered as non-compliance. MCA gave a clarification. That is this clarification. MCA wide notification dated introduced an amendment in Schedule 3, that is balance sheets and P&L, whereby the companies were mandated to round off the figures appearing in the financial statements depending upon their total income. Now MCA has issued clarification that in case the companies provide an absolute figure in AOC 4, the same shall not be treated as incorrect certification by professionals. So if a CS certifies it, so in the form, sir, we did not round it off, will I be punishable? They said it will not be considered as incorrect. Even if you have not rounded off it in the form, it's fine. You can still file it, is what they're telling. Clear? Okay. Simple thing that you can ignore also. Okay. Sir, they have added some case laws in chapter 9, people. What is a simple case law? The case law says people Anir Kumar Podar versus Eswile Trading Private Limited. What happened in this case law, people? Very simple. If you guys see, people, there is a section called as section 94. If you guys see section 94, people, the section 94 clearly says, okay, let me show you only. Okay. So, what was the issue, people? Okay, now imagine, according to section 94, that you can go and inspect the register of members of a company. Okay. Now, there was one person, people, he wanted to inspect the register of members. Now, who was he, sir? He was not a shareholder. He was not a creditor. He was not a debenture holder. He was nowhere connected with the company. Now, the question was, people, can such person who is nowhere connected with the company, he was just walking on the road, I'm just giving you an example, absolutely a stranger, he wants to come and check the register of members of a company. Now, the question is, can such people come and check? Is it allowed? Is it possible, first of all? Now, people, so he filed a notice to the company saying that I want to come and check the register of members of a company. I don't mind paying fees also. You can please give me the access. The company said we cannot give you the access to the internal documents of the company. Sorry for the inconvenience. We are not willing to share these information with you. So that was a reply given by the company. Now, what happened, people? The person said, according to Companies Act, according to Companies Act, the company is under an obligation to give me the registers for inspection. How can you say that you are not giving me the documents for inspection? The person filed a suit on the company that how can they not follow? Now, people, when the person filed the case on the company, the person quoted this section. What is the section, people? Section 94. You can see the subsection 2. The registers and their indices, except when they are closed to the provisions of this act, the copies of all written shall be open for inspection by any member, comma, debenture holder, comma, other security holder or beneficial owner, comma, during business hours without payment of any fees, and by any other person on payment of such fees as may be prescribed. He can comment. So, if you are them, you need not pay fees. If at all any other person, they have to come and pay the fees. So he said, sir, any other person, I'm any other person, I'm a stranger. I have a right to come and check the books. So why are you not allowing me? That is a query he raised. The matter went to court. Now in the court, people, now I'm giving you a cross reference to the, another subject only called as jurisprudence. In jurisprudence, people, you guys have studied something called as your interpretation of statutes. In that, you had something called as ejusdem generis. In ejusdem generis, what is that, people? Whenever there is any general word used, the general word always takes the color of special word. Correct? I hope you guys remember. For example, if I write, say for example, cat, dog, etc. In that etc. will tiger come and sit? Will lion come and sit? That etc. should be read in accordance with the previous words. So I might be referring to pets. Correct? So people, the courts refer to ejusdem generis and they said whenever they are writing here as any other person, the any other person here does not mean that he is a random person. You have to read it in the context. Meaning, people, they are telling you any member, comma, debenture holder, other security holder or beneficial holder. So if they are coming without fees, if any other person here can be a creditor, can be a bank, if they have given money. So basically you are somewhere connected to the company. So it cannot be an absolute stranger. In this case, this was decided, people, saying that this person does not have a right to go and inspect the register of members because he is not connected to the company in any way. Ejusdem generis was, sorted in this particular case. Yes, that is what is given in this entire case law. Yes, people. So just give a, random read once, more than sufficient. See, any other person, ejusdem generis, that was the case law. The next ones are In the matter of Suhas Chakma versus South Asia Human Rights Documentation Center Private Limited. Okay, in this case, what happened, people? There was a person shareholder. The shareholder people, after say some randomly one day, he went to inspect the register of members. When he saw people, it came to a surprise that this person was no longer a shareholder in the company. But he is telling that I'm not at all, I did not sign any share transfer. I did not sell my shares. I did not give it as a gift to anyone. How can you guys transfer the shares to some other person, which I have never signed? I did not transfer it to any person. So basically what has happened, people, someone has given something called as forced transfer. Someone has signed this person's signature and they have gone and given SH4 to the company. The company has also recorded the transfer and they have registered the shares in the person whoever has fraudulently done it. So they have changed it to another person's name. Now the question was, people, the company is arguing that, sir, whatever we did is a absolute transfer, correct? And they are telling you, sir, the actual word prima facie. Now see here. Okay, let us read once. I'll tell you the exact words. The contention of petitioner is that he never executed any instrument. Petitioner is the person who has filed the case. He has never signed any instrument of transfer of his shareholding to the second respondent. He never transferred. And that he came to know that he was not a shareholder of the first respondent company by virtue of inspection of annual return. So when he checked the annual return, he got to know that his name was not there. And illegal and fraudulent transfer of his share has taken place. He came to know about the same only upon the perusal of the annual return after checking. The NCLT New Delhi bench observed that in view of the wordings used in section 164 of Companies Act, today section 95 under Companies Act, to the effect that the register, returns and documents, people, what are those, people? If you see section 95, it says whatever are the registers, documents, returns which is preserved by the company, those documents will be considered as prima facie evidence. Yes, sir. Sir, what do you mean by, okay, read the entire thing. And hence, subject to rebuttal and therefore cannot be treated as conclusive evidence. And in absence of share transfer forms, specified share certificates, letter of allotment in question, transfer of equity shares of petitioner by respondents were fraudulent and sham and declare it to be illegal and void. Meaning what, people? So the company started arguing that, sir, whatever we have given in annual returns, for now we have been giving it for the last 3 years, whatever names are given in registers, returns, register of members, according to section 95, it says that this is only the prima facie evidence. So this is conclusive evidence. I mean, this is the prima facie evidence, sir, that the second person is a shareholder and you are not the shareholder. People, when they went into detailed, people, they saw difference between two words. Section 95 says whatever are the details given in registers, returns and these documents, that will be considered as a prima facie evidence. What do you mean by prima facie evidence, people? Primarily, yes, this is true. If nothing is given, that is true. However, on inspection, if something can be proven, now that is called as, people, conclusive evidence. Meaning, people, prima facie evidence means, people, on the face of it, yes, that is what has happened. Conclusive evidence means, people, if you go in detail, meaning if you can prove it. Sir, if you can prove it, sir, the facts can change. Sir, that is called as conclusive evidence. Sir, if someone is giving you conclusive evidence, if someone is giving you prima facie evidence, conclusive evidence will always have the weightage. Prima facie is always primarily on the face of it. Yes, that is how it is visible. But when you go in detail, people, that is not the case. So, section 95 says this registers, returns, documents are just a prima facie evidence. On the face of it, yes, this is true. But then how will I know, sir, how to go in detail? People, the first shareholder just asked one question to the company. What? Show me the SH4 they have given. The company did not have it. Okay, show me the share certificates. The person gave it to you. The company does not have it. Then when you do not have any evidence, how can you say that the first shareholder is not the owner? So it was considered that the entire share transfer was a sham, meaning, people, it was illegal and void. It was cancelled. The first shareholder only continued to become a owner. Clear? That's all. Then practical aspects, people, of guilds In the class only we have done this, people. This is clearly discussed, so you can refer to whatever was done in class only. Okay, there's one clarification given, people. This clarification is also not important for us. Basically, this is somewhere related to LODR. Companies that directly doesn't have relevance. So what happened, people? From April 1st, 2022, they have changed something called as, so there is two types of transaction. One is called as related party transaction. Next one is called as material related party transaction. Now, what is material related party transaction? That definition was changed from April 1st, that amendment came in April 1st, 2022. So what did they say, people? So whenever you guys have to go for related party transaction, we have already seen you should take a prior approval of audit committee and you should have taken prior approval of shareholders. So now the question was, then amendment came that they changed the limits, correct? Yes, sir. So now they are asking people, now whatever are the limits that are changing. Now for this, should we take again fresh approval of shareholders? Is it required? Or if we have already taken according to our previous definition, according to that it was material or not material, according to that we have taken the shareholders approval and audit committee approval. Should we again take shareholders approval was the question. For that, people, they have given a clarification. What is that? It was clarified that that has been approved by audit committee and shareholder, any related party transaction that has been approved by audit committee and shareholders prior to April 1st, 2022, there shall be no requirement to seek fresh approval from shareholders again. The related party that has been approved by audit committee prior to April 1st, 2022, which continues beyond such date and becomes material as per the revised materiality threshold, shall be placed before the shareholders in the first general meeting held after April 1st, 2022. What is that, sir? If you have already taken shareholders approval, people, then they said you need not take again shareholders approval, not required. However, previously, people, if at all you have taken audit committee approval, but you have not taken shareholders approval yet. Now, for this, what you need to do, people, audit committee approval is taken, that is done and dusted. However, with regards to your shareholders approval, they are telling you whatever is the first meeting you will be conducting after April 1st, 2022. In that first meeting, people, you need to make sure you take shareholders approval for such transaction, which is considered as material related party transaction. So what is material related party transaction? According to our LODR limits, we have not seen this. You need not even worry. Sir, when we are calling shareholders for, passing this resolution because we are taking their approval, right? In the explanatory statement, you have to clearly disclose all the information. What is the transaction about? If we had entered into with unrelated party transaction, what would have been the effect? If we are entering it with them, what is the effect? You have to clearly disclose everything. Is clear, people? Yes, all of you. Pakka. Okay, sir.